Thanks for turning early, everybody. Tom's on a tight schedule, so we're very privileged to have him here. And given that I changed the program around, I apologise, Tom. Very pleased to have you with us, of course. I just wanted to remind people that this is being recorded, so I thought the first session was absolutely fantastic, and it means that once it's up on the CNTA website, you can go to it and go over it in your own organisation and dissect and discuss and so forth. And I mentioned that the Federal Court is also running the brown bag sessions. They're also recorded. And if you are interested in any of those but it's not convenient to meet, then you can request a recording from them of that particular session. And again, it's available to use in-house with your own in-house training. So two great resources for you. Thank you. Tim?
Thank you, Julie. I hasten to add, brown bag session doesn't imply that someone's going to give you a little bag full of money. My name's Tim Wishart. I'm the Chief Executive Officer of Queensland South Native Title Services. It's always good to come back to Melbourne. I was born in a hospital that was then called the Mercy Hospital, which is in Grey Street, East Melbourne, about 10 minutes walk down the road. And I spent the first 21 years of my life in a little town called Sorrento, which is about 2 hours south of here. So it's sort of like coming back to country. And speaking of country, I should acknowledge and offer my respect to the country on which we're gathered and to the traditional owners of this country, the Wurundjeri and Bunurong people of the Kulin Nation, and to their old people and elders, and acknowledge that sovereignty was never ceded over this country and that it always was and always will be Aboriginal land. I'm taking a little bit of Tom's time, but I just want to say this. One of the things that has vexed me in native title land is the hard lines we're forced to put on maps about boundaries. And very often everyone in this room will know that the traditional owners we work with arc up about boundaries. We are standing next to a really hard boundary. A really hard boundary. I'm a relatively passionate Brisbane Lions supporter. I am safe on this side of Smith Street. The other side of Smith Street is Collingwood. Those of you who know Aussie rules will understand the significance of that. It's my great pleasure to introduce Tom Keely. Tom is a senior counsel practising primarily at the Melbourne Bar. He was admitted to practice on the 2nd of April 1979, although if you read his entry on his chambers sheet, it says the 1st of April 1979, so there's an error there somewhere. He signed the bar roll in March of 1981 and he took silk in November of 2015. He took leave from the bar for a few years where he was practising primarily in civil and criminal law to, in 1986, go to Alice Springs where he worked with the Central Land Council until August of 1989. And those of you who have heard those dates will realise that that was pre-Mabo. So pretty interesting time to be doing Aboriginal law for a white fella barrister from Melbourne, I think. Tom's worked in a lot of significant cases. He did, according to the CV I've seen, 19 matters under the Aboriginal Land Rights Northern Territory Act. And for the case law nerds amongst us, if I say the names Yorta Yorta, Aliwar, Hazelbane, Aqaba, Sampi, Manadeo and Jawal, you'll go, oh! Tom's been in all those cases. Would you please welcome Tom?
Thanks very much, Tim, for those kind words. I think the dates that you've highlighted make clear to everybody how old I am, which is a bit sad. I too acknowledge the traditional owners and custodians of the lands on which we meet today and pay my respects to their elders past, present and emerging. There will be a paper that Julie will circulate later for those who may be interested, which sets out the guts of what I will say in oral presentation. It'll include references and the like, and it may include some content that we don't get to in talking here now. My topic is anthropologists and lawyers working together effectively. It's not an academic issue. I remember when I arrived at the Central Land Council, and in the time that I was there were tensions between the legal section and the anthropology section. I thought we were just doing our jobs. The anthropologists thought, I think, that we had too much say in how things went, particularly with land claims and legal processes, which, as I think most of you would understand, legal processes have to be run by lawyers. But we'll come to the role of anthropologists shortly. I argue, therefore, that the principal proposition is this, that in order for there to be an effective working relationship between lawyers and anthropologists, it's necessary that each understands not only their own role, but the role of the other. No doubt there are other factors that are needed to have effective working relationships, and perhaps foremost among them are mutual professional courtesy and respect. And I would observe there that there have been odd times that I've observed myself that not being adhered to. It seems to me that if you've got interdisciplinary teams working on projects, that is a basic prerequisite. On occasions, I've sensed that some anthropologists, particularly those who are inexperienced as expert witnesses, have approached interactions with lawyers with a degree of wariness or even defensiveness. In my view, a proper understanding of the roles of each can allay concerns of that kind. I've also sensed over the years that at least some anthropologists feel undervalued, and I'd be interested to know whether that's the view of the anthropologists who are here today. One small example is that this comment was directed to me by a capable and respected anthropologist on a case that we were working on many years ago, and he described the case as an anthropology-free zone. That wasn't literally true, but it conveyed his feeling that we weren't taking as much notice of what he had to say as we should have been. That case occurred in the post-Jungler environment, and I'll come to Jungler in due course, and I think that did affect the way we did things. It certainly made me stop and think. For my part, I've found anthropologists to be generally very helpful in gaining a proper understanding of the case at hand. There are many things that lawyers will not understand having just read the papers that come with a case. For example, why is a prospective witness saying that he or she, why is she saying X when elsewhere the person has said Y? Why is a witness reluctant to talk to lawyers? What are the background politics that may be influencing what people are saying and what positions they are adopting? Lawyers know none of those things unless they're told about them by, usually, the anthropologist. So I'll turn to the question of lawyers' obligations, and hopefully this isn't too dreary, but here we go. So the first obvious point is that unlike anthropologists, lawyers are advocates. That's our reason for existence. That, of course, does not mean that anything goes. Focusing on barristers, as distinct from lawyers more generally, their conduct is governed by the Legal Profession Uniform Conduct Barristers Rules of 2015, which are enforced by the Legal Services Board and Commissioner. That's in Victoria. Among other things, the rules identify as principles that barristers owe their paramount duty to the administration of justice and should exercise their forensic judgments and give their advice independently and for the proper administration of justice, notwithstanding any contrary desires of their clients. Among other things, the rules also provide that a barrister must not engage in conduct that is dishonest or otherwise discreditable, prejudicial to the administration of justice, or which might diminish public confidence in the legal profession or the administration of justice. Secondly, a barrister must not deceive or knowingly or recklessly mislead a court, and must take all necessary steps to correct any statement that has been made already and which proves to be misleading or not correct. Thirdly, a barrister must promote and protect fearlessly and by all proper and lawful means the client's best interests to the best of the barrister's skill and ability, and do so without regard to his or her own interest or to any consequences for the barrister or to any other person. So that's a very clear statement that barristers are advocates, they are partisan, they have to work within the rules, but they have to prosecute their client's cause with all reasonable means and diligence. Next, a barrister must not act as a mere mouthpiece of the client or of the instructing solicitor, and must exercise the forensic judgments called for during the case independently and after appropriate consideration of the wishes of the client and the solicitor. That means that if, for example, a client says to you, I want you to go and ask the next witness about this, and you can look at it and think about it, and you can say yes or you can say no. You are not duty-bound to put things merely because the solicitor or the client has asked you to do so. You're independent, and you exercise a judgment in that circumstance about whether to ask the question that has been suggested is going to help your case or hurt it, and you make that and move on. Next, a barrister must not allege any matter of fact unless he or she believes on reasonable grounds that the factual material already available provides a proper basis for it. And lastly, a barrister must not advise or suggest to a witness that false or misleading evidence should be given, nor condone any other person doing so, nor must he or she coach the witness by advising what answers the witness should give to the questions that might be asked. All of those statements are pretty clear, but there are some areas in practice which are grey, which are less clear, and where you, understanding what your obligations are, make a decision as to what you should do. I won't go into this, but for completeness, lawyers and parties also have obligations under the Federal Court of Australia Act in terms of how they go about prosecuting matters, but that's perhaps beyond the scope of what we're talking about. Can I move to anthropologists' obligations? In native title proceedings, the role, and I'm talking about anthropologists as expert witnesses in cases before the court. So where that's the case, the anthropologist is bound by the practice note, which includes the court's harmonised expert witness code of conduct, and you will all be familiar with that. It's been mentioned already this morning. The document is almost inevitably exhibited, in my experience, to terms of reference that are provided to anthropologists, but it's been around for so long now that everyone knows of it and knows of its contents. Without going to the code in detail, for present purposes, attention is drawn to the following important provisions. First, an expert witness is not an advocate for a party and has a paramount duty, overriding any duty to the party in the proceedings or other person retaining the expert witness, to assist the court. Barristers have duties to assist the court as well, and they are very important in a barrister's professional life, but anthropologists' primary duty is not to the people, not to the rep body, it's to the court. Secondly, every report prepared by an expert witness for use in court shall clearly state the opinions of the expert and shall state the assumptions and material facts that each opinion expressed in the report is based. That's been canvassed already with His Honour and perhaps doesn't need to be considered any further. Thirdly, where an expert witness has provided to a party or that party's legal representative a report for use in court, and the expert thereafter changes his or her opinion on a material matter, the expert shall forthwith provide to the party or the party's legal representative a supplementary report. That's very seldom happens in my experience, but it did happen in Akiba, where the state engaged Professor Basil Sanson to consider the facts of the matter, and if I remember correctly, they didn't end up calling him, and we received a change of opinion report from him. So that having heard the evidence, a lot of the points raised in his initial report were abandoned by him. So bear in mind that there's an obligation on you as anthropologists to file a supplementary report if you change your view. And there's nothing wrong with changing your view if the facts justify it. There's also, as anthropologists, and I'm sure you'd all know, there's the Code of Ethics of the Australian Anthropological Society. There are no doubt others in the room who can speak much more authoritatively on those than me, so I'll simply mention it and move on. There are a number of key points where lawyers and anthropologists interact in the court process. And it was said earlier that the role of anthropologists in court processes is different than that in other fields. I was going to give you, having once practiced in personal injuries law, the example of a doctor who might see the injured person for 15 minutes, 20 minutes, half an hour, read a small bundle of papers that are given to them, and then provide an opinion to the solicitor about the nature of the injury, the extent of the injury and its cause. Your job as anthropologists is far different and far more difficult in my view, because you typically have a mountain of materials to wade through. You've got to go and do field work, you've got to talk to people with differing perspectives on things, and then transform all of that information into something that is cogent and useful to the court in reports that are often very lengthy. So I think the three most important stages of lawyer-anthropologist interaction in this process are, firstly, the initial engagement of the anthropologist, secondly, the finalisation, or some people say settling, of the anthropologist's report, and thirdly, prior to the expert participating in either a conference of experts or giving evidence at trial. If I spend a moment on the initial engagement of the anthropologist, that's obviously an important step, not only in terms of which anthropologist is engaged, because there are horses for courses in anthropology as there are everywhere else, but also identifying exactly what the anthropologist is to be asked to do. Terms of reference should not be formulaic, but should be carefully tailored to the particular issues that arise in the case. I respectfully agree with all that the judge said about using the concepts of the Native Title Act. I would think with one exception, I think every lawyer who's drawn terms of reference would mention society, and I don't really resile from that because it has been over 2 decades or more a central element of native title jurisprudence. I understand Kevin Murphy's going to talk later about the current status of the society requirement, which might be in recession. In any event, it's common, in my experience at least, for terms of reference to have accompany them some instruction to the anthropologist. And I think the judge may have touched on this too. So that if you're going to use the word society, you tell them what that means, yorta yorta, paragraph 84 or whatever it was. If you're going to talk about permissible adaptation, explain what is meant by that. If you're going to talk about traditional laws and customs, explain what yorta yorta said about that. More recent concepts are overlapping native titles, which I'm sure you'll have read Drury, and that's an interesting decision. Whether or not if there's 2 groups with native title in the one area, whether their native title springs from one set of laws and customs or multiple sets of laws and customs. So I think I encourage terms of reference to have those kind of pointers to them, drawn in very neutral terms, so that the anthropologist, on reflecting on terms of reference, can consider what the courts have said, because that's really what we're after. There have been anthropological reports which talk about society in anthropological terms, which is different than the yorta yorta definition. And I understand why anthropologists might gravitate towards that, but really the important definition is the legal definition. I generally ask for terms of reference to be circulated to the anthropologist as a draft in advance of them being settled. The lawyer has to take the final responsibility for the form of the terms of reference, but anthropologists not uncommonly give interesting and good feedback about, well, have you thought about this? That's not quite right the way you've expressed that, and so on. Its only purpose is to make sure that the anthropologist engages with the issues in the case. Now, the second stage is finalising or settling expert reports. In Harrington Smith, so Wongatha, Justice Lingren said this: lawyers should be involved in the writing of reports by experts, not of course in relation to the substance of the reports, in particular in arriving at the opinions to be expressed, but in relation to their form, in order to ensure that the legal tests of admissibility are addressed. That passage has been cited in various subsequent cases with approval. It does not, however, in my opinion, reflect the limits of what a lawyer can do in terms of discussions with an anthropologist. I doubt that anyone would argue against the idea that a lawyer is entitled to draw an expert's attention to mistakes in the report that are of law or fact, a failure on the part of the expert to address the entirety of the terms of reference, a failure on the part of the expert to address evidence that the author has been asked to consider. I think those matters ought to be uncontroversial. So, as you would all know, we get a draft report, the lawyers pore over it, consider it, and then there's feedback to the anthropologist. In my view, a lawyer is entitled to draw attention to what he or she might see as being any internal inconsistency in the report, and to ask questions such as, at paragraph X you express such and such an opinion but don't mention factor Y. Have you considered that factor informing your opinion? Those sort of open-ended questions I don't think there should be any difficulty with, and that's certainly the way that I go about things. There are certain things, though, that are really crystal clear that a lawyer cannot do, and I'll give you some examples. There's a recent article published in the Australian Law Journal that proffers some helpful guidance, and they say as follows, the authors, who are two Australian government solicitor lawyers who have experience in litigation. Firstly, its advice is that lawyers should be careful to avoid communications which might be or might be seen to be distorting of the witness's independence. Secondly, lawyers should not influence the content of the report to the extent that the report does not accurately reflect the expert's honest and independent opinion. The authors acknowledge that there are few bright-line rules and add the appropriate level of lawyer involvement in preparing an expert report depends on the circumstances of the case. There's not one rule or practice which covers all experts or situations. So that may not be as helpful as you might like, but it reflects the reality that what a lawyer can and should do in a given situation may vary on a case-by-case basis. Lawyers obviously have to be vigilant not to coach any witness, including expert witnesses. They must also be vigilant not to compromise the independence of the expert. From the anthropologist's point of view, he or she must be vigilant to see that their independence is not, in fact, compromised. They must keep in mind that their report and their oral evidence must be true to their own opinions and their own understanding of the facts. They must also keep in mind that it's the anthropologist, not anybody else, who will be cross-examined about his or her opinions, understanding of the facts, method of preparing the report, and so forth. I return a little later to the question of independence when considering Justice Sackville's decision in Django. The third point at which lawyers and anthropologists interact in the court process is generally either a conference of experts before trial, which you probably all know, but in case there's anyone who doesn't, a conference of experts is handled generally by a registrar of the court. A whole lot of propositions come into being. Lawyers are not in the room, and the registrar and the anthropologists work through the list of propositions and at the end of the day prepare a report which is signed by each anthropologist and the registrar, which reflects the outcomes. Proposition 1, agree, disagree with qualifications and record whatever those qualifications may be. They're very useful documents and they often find their way into the court evidence. In my view, it's part of a lawyer's job to make sure that the anthropologist, particularly one who's not experienced in giving evidence, has a good appreciation of the process ahead. So, for example, if you're at trial, the anthropologist is going to need to know what kind of evidence are we talking about. Are we talking about old-fashioned evidence in chief, cross-examination, re-examination, or are we talking about concurrent evidence, which tends to have its own dynamic? And I should perhaps pause there just to recall a comment that Lee Sackett made to me once after going through a conference of experts. He said he felt really empowered by it. It was the first time that he thought his views had been listened to and digested free of any external interference, which I thought was very interesting. I think there are pros and cons of which way you might want to go in a given situation, and ultimately, of course, it's a matter for the judge as to whether it's concurrent evidence or the old-fashioned way of doing things. People who are not familiar with the process will have a host of questions about how it works. What should I do if the question's not clear? And believe it or not, lawyers sometimes ask unclear questions. What happens if you need to look up your report or your notes in order to answer a question? How confined should your answer be to the question that's been asked, and does that differ between evidence in chief and cross-examination? What happens if you wish to qualify an answer that you've already given, and as time's gone on, you've thought, no, that's not quite right, I need to qualify what I said earlier? What should you do in that situation? Another matter that can be touched on in those sorts of discussions is who is the relevant judge and what are her known likes and dislikes. The second matter that I think the expert needs to sit down and have a discussion about before going to a conference of experts or going to give evidence at trial relates to substantive issues. By this time, the experts' opinions will already be laid out in one or more reports. There may have been responsive reports and so on. I take the view, and I think it's correct, that a lawyer's duty is to, in some respects, protect an anthropologist from himself or herself. That doesn't apply to everybody, but sometimes you meet people who are new at it and who are very enthusiastic and very keen to help. I think you need to hose people down. Because the simple reason is that if they give their evidence like that, it will be discounted. And that doesn't help the case, it doesn't help the clients. In other respects, I think you not only are entitled to, but I think you're obliged to talk things through with the anthropologist, not with a view to the person adopting any view you might have, and I think you need to be careful about expressing personal views, but so that the person has thought through what may be coming. Everyone will have read the reports, but there might be particular things that you want to say, well, you might be asked about this. Have a think about how you're going to deal with that. It's your task to think about it and to give your honest opinion in relation to it. A lawyer can never, and I say never, say to a witness, expert or otherwise, that you should answer this question in this way. It's just quite wrong for that to occur, and it should never occur. But it's another thing to discuss the competing points of view with a view to making sure that your expert has considered the range of possibilities that might exist. Finally, on that point, in relation to concurrent expert evidence, as you'd all know, the practice note deals specifically with concurrent evidence and how that should go. I want to move to discussing some pitfalls. I'm not sure how we're going with time. I've mentioned Django a couple of times, and it was a landmark case in terms of lawyer anthropology relations and lawyer anthropology roles. Justice Sackville was critical, some would say very critical, of the way in which the primary expert anthropologist, Professor Peter Sutton, had been utilised in the course of the claim and the hearing. His Honour acknowledged what I expect everyone in this room knows, which is that Peter Sutton's very well qualified, has extensive experience as a social and linguistic anthropologist, and that his publications are highly regarded. So none of that being in an elevated position in terms of his status within the anthropology profession saved him from what the judge made of his evidence. His Honour drew attention to Professor Sutton's involvement in the case preparation and hearing in a number of ways that were beyond his brief to write a report and to give expert evidence. He said this: "I formed the view that Professor Sutton played an active role in formulating and preparing the applicant's case, and that this participation influenced both the way in which their case was presented and Professor Sutton's approach in giving evidence." He then identified, that is the judge, various matters in which Professor Sutton had played a role. So first, he said he spent considerable time commenting on draft witness statements, and His Honour inferred that he had clearly played a significant part in shaping witness statements. Secondly, Professor Sutton, according to the judgment, had rejected the original points of claim in the case. Thirdly, he had given some advice to the lawyers whom he considered would be good witnesses, and he sat in close proximity to counsel during the hearing, and the judge the judge pointed out that Professor Sutton had acknowledged that he had suggested questions to counsel while he was sitting there, at least from time to time. Justice Sackville relied on these and some other matters, including what he found to be a tone of defensiveness during Professor Sutton's cross-examination, in finding that his role had not been limited to that of a wholly objective expert observer and commentator. The consequence of this was that His Honour was more prepared to accept Professor Sutton's opinions if they were corroborated by other evidence, and it seems, where that was not the case, to give them more than normal scrutiny to see whether they stacked up. A number of points can be made about this. First, Professor Sutton no doubt undertook these tasks because he was asked to do so by the lawyers. To the extent that it's profitable to apportion blame, I would have thought that the lawyers would bear the lion's share of it. Secondly, Django was mainly heard in 2003, 2004, and was therefore one of the earlier native title cases to go to court. The ground rules at that point had not been fully worked out. Professor Sutton had given evidence in numerous land claims in the Northern Territory, and those claims proceeded in a very different legal context. The Territory land rights experience was also undoubtedly influential in the way lawyers presented native title cases, particularly in the early days, because it was the same people who were involved by and large. Thirdly, Django sent, I say, shockwaves through the group of native title lawyers who typically appeared for claimants. After Django, there were cases where consulting experts, sometimes called dirty experts, were engaged. So an anthropologist was engaged to help the lawyers, but who would have no formal role in the court process. I note, however, that if you go to the practice note, the expert evidence practice note at paragraph 3.2, the court discourages this practice. It's important to note that there's no principle of law or practice, and there is nothing in this practice note that obliges a party to embark on the costly task of engaging a consulting expert in order to avoid contamination of the expert who will give evidence. Indeed, the court would generally discourage such costly duplication. In some cases, the role of a consulting expert may be able to be performed by a rep body anthropologist, but that's obviously not always the case. Of the tasks that Justice Sackville mentioned in connection with Peter Sutton, I would say these as follows. I would agree with respect that the expert anthropologist should not be commenting on or shaping draft witness statements. That's the lawyer's job. The lawyer can talk to the anthropologist about the issues that arise and so on, but the witness statements have to be the lawyer's work. If there's an in-house anthropologist who can look at and help you with that process, well and good, no problem. It's the going to court and the being the independent expert that creates the problem. Secondly, I'd agree that the expert anthropologist should not be sitting in close proximity to counsel, passing notes, suggesting questions and the like. And that's the way it did happen back in the day, or at least it happened in some cases, depending on the personalities. Thirdly, with respect, I don't agree that the expert anthropologist should never tell the lawyers acting for claimants who they think might be good witnesses. I'm not sure that the judge went that far, but he did say, in pointing out some what he thought were anomalies of the way it had been presented in front of him, that Professor Sutton had been recommending witnesses and so on. For my part, I don't see anything wrong with asking an anthropologist who should we talk to, because the alternative might be, if you don't ask that question, the alternative might be that you proceed in an era or in an air of ignorance and perhaps miss people who would be good witnesses. I don't think we're required to refrain from asking that question. I'll move on to discuss briefly the question of advocacy and partisanship by expert witnesses. It's not uncommon for the submission to be made by government or by a respondent party that expert anthropologists who've been called to give evidence are acting as advocates, or that they're predisposed in their opinions towards the claimants, or that they've not been dispassionate or lost objectivity. In some cases, submissions of that kind have been rejected, and I give some references to that. In other cases, however, the courts found that the anthropologist or other expert, whether it be a linguist or a historian, archaeologist, has assumed the role of an advocate and at least I should say, has had a tendency towards advocacy on behalf of the claimant group. A finding that the anthropologist or other expert has assumed the role of an advocate or has had a tendency towards advocacy is generally not a finding about the person's honesty. By way of example, in one fairly recent case, the judge made a finding that a particular expert had departed from his independent position as an expert and had become an advocate, at the same time accepting that this stems from his genuine beliefs based on his experience and expertise. Equally, though, the mere making of the submission that an expert is not impartial, has become an advocate, I've seen myself, can be perceived by the expert as being an attack on their integrity and therefore deeply upsetting. It follows, in my view, that a submission about partisanship should not be made by lawyers without a proper basis for it. In my view, lawyers have a role in educating experts, particularly less experienced ones, about the dangers of slippage into advocacy. If this occurs, it's necessary for the lawyer to try and curb the enthusiasm. It needs to be understood by the expert that if that kind of finding is made, his or her evidence is likely to be discounted, which obviously doesn't help the case. Now, you might wonder what are the kind of examples of what are the indicia of slipping into advocacy? And I've collected these examples. First, an anthropologist who accepts statements by informants at face value when the circumstances really require that those statements be interrogated. Secondly, where an anthropologist fails to address or skates over adverse evidence. Thirdly, where an anthropologist, in giving oral evidence, fails to make appropriate concessions or has to have those concessions dragged out of them. Fourthly, that an anthropologist has failed to answer questions in cross-examination, or instead of answering the question, gives a long, discursive and non-responsive answer. Fifthly, where the anthropologist has been prone to the use of hyperbole and strong language where that language is not warranted, or has failed to qualify statements of opinion that required qualification. Next, where the anthropologist has gratuitously offered criticisms of the opposing expert intended to discredit him or her. And lastly, because this was mentioned by Justice Sackville in Django, being unduly defensive in cross-examination, although I think that is a conclusion that some courts may arrive at on a shaky foundation. In other words, I think anthropologists, many of them will be very nervous before giving evidence, and I think one ought to be careful to arrive at the conclusion that there's defensiveness, which implies that you're a bit embarrassed perhaps about some of the opinions you've expressed. I'm getting the wind up. I just want to say two further things. One of them I won't go to at all, but I've extracted in the paper a bit of a snapshot over time of the role of anthropologists since 1976 when the Land Rights Act was passed, and surprised myself to see how big a change there's been. Anthropologists played almost a dominant role in statutory land rights claims in the Territory, And even in Queensland, I read a transcript not that long ago of a case in Queensland where Professor Bruce Rigsby asked the questions. The lawyer handed over to him to ask the questions and to elicit the evidence. And I guess the anthropologists in the room might understand that, because you probably think you're better at doing that than most lawyers, and you're probably right. But it's the lawyer's task to do it nevertheless. So I won't go into that, but I'll just say something finally about Munkara and Santos, which you probably all know about. It strikes me as being a bit of a low point in acting for claimant groups. There's many lessons to be learned from Justice Charles Worth's very lengthy decision in this case. So this was about an undersea pipeline off the Tiwi Islands, some distance, some kilometres off the Tiwi Islands. There's lessons both for lawyers and for experts in the case. I think it also highlights the difficulties that can arise where environmental groups enlist Indigenous witnesses in support of their environmental objectives, such as stopping a particular development. I think great care needs to be exercised in that scenario. For present purposes, and finally, I'll just draw attention to these findings by Her Honour. First, Her Honour found that a lawyer and an anthropologist had engaged in a form of subtle coaching of Indigenous people to tell their cultural stories in a particular way. This undermined Her Honour's confidence in the reliability of that evidence. Secondly, concerns were raised about the independence of an anthropologist who had participated in discussions about the strategies that could be adopted by the Indigenous people at a point in time when legal proceedings were in contemplation, and that the anthropologist had gone about his task by eliciting information that would stop the pipeline rather than as an anthropological inquiry carried out with a neutral attitude in the ultimate outcome. Thirdly and lastly, Her Honour found that an anthropologist had assumed the role of advocating an arguable or defensible answer to a particular question, as opposed to answering it in an open, neutral and evidence-based way. Her Honour didn't stop at criticising lawyers and anthropologists. She was also very critical of an expert witness in the field of marine science. But there are lots of lessons to learn from Munkara, and no doubt you'll in your spare time be able to have a look at some of the things that Her Honour has said there. Now, that's all I wanted to say, but I'm happy to field any questions if there are questions. Everyone's convinced.
Thanks, Tom. I'd prepared a Dorothy Dixer, but my appalling chairing has run Tom out of time and he needs to be somewhere else. Would you please thank Tom for his contribution in the usual way? Thanks, Tom. No worries. I'll talk to you before then.
We've got something from CTA. Thank you very much.
Thanks very much, Julie. Okay, thank you.